We start with the second lecture of the webinar series. Our today's topic is the criminal justice system in India, the current challenges, and the speaker for the same is Mr. Sudeep Pasbola, a leading criminal lawyer in Mumbai. The sir has been practicing in the field of criminal law for more than 30 years, with his cases finding coverage in the leading newspapers, and he's been making headlines as a defense attorney in various cases. To name a few, the familiar one. I request participants to keep their microphones off, please. To name the few of these cases are the Rahul Gandhi defamation case, the extradition of Abdul Salim, and the 1993 bomb blast case, the B. Blunt sensational murder case, and the most renowned of them all, the ongoing trial of the Sheena Bora murder case. Sir has gained mastery in the field of criminal trial through his marvelous skill of cross-examination and unparalleled forte in the trials and other special laws such as Maharashtra Control of Organized Crime Act of 1999. Sir is also currently the member of Bar Council of Maharashtra and Goa. Sir, I would like you to take it ahead from here. We're extremely sorry for the technical issue.
Can you hear me now and can you see me?
Yes, we can, sir.
Okay. Good morning. Good morning, Gauri. Thank you for having me on this program. And the subject for today, which is we have given me, the criminal justice system in India and the current challenges faced by the criminal justice system. Now, so many things have been said on this subject. I think I'm audible to everybody?
Yes, sir, you're audible.
Am I audible? Yeah, okay.
Yes, sir.
Now, so many things have been said, written on this subject of the challenges faced by criminal justice system. Today, I will try to give you an insight on the practical aspects of the difficulties which are faced in the present criminal justice system. What are the challenges and how we can address those challenges. A few of things can be said in this program. So many things cannot be, everything cannot be encompassed. But let us try to understand what is the criminal justice system. Now, in a society has to work in an orderly manner. In the society, there are people who take advantages, who would try to bully the weak, the poor, and take advantage. So the society lays down certain rules, certain laws, and for these laws, which are framed by the society, they are to be governed, they are to be enforced. So they are to be enforced, and for these purposes, there are the police to enforce the law, to educate. There is a court to educate these rights. So on this principle, the criminal justice system is based. Basically, the criminal justice system is to four things: to protect the weak against the strong, to protect the invasion of the right of an individual, to protect the person, his property, the property of a person, to protect and the law-abiding citizen against the lawlessness, and peaceful against the violence. These are the aspects on which the criminal law is based. Now, in the criminal law justice system, right, there are certain pillars of criminal law justice system. One, which is the legislature, which they call the parliament, who form the law, who lays down the law. Then we have the police or the executive to enforce those laws. Then there is a third pillar, which is called the courts, which is the main pillar for educating these laws. And lastly, the corrections which we call the prison or the persons where after the person has been given punishment is kept for Now these are the four pillars on which the criminal justice system works. Now a fifth a pillar is also added to it, which is the community. The community means we all, that we are participant to this criminal justice system. Now the basic idea of the criminal justice system is fourfold. One which is very, I'll just point out, which is this thing. The objectives are, one is the retribution, because a person who has been aggrieved wants a retribution. He wants that he should be his whatever he has suffered, he should be paid for that, but he should be recover that the things. If he has been a victim of the crime, the person should be punished, and therefore this is the retributive theory which we have seen in the theory of punishment. So that is the one basic principle of criminal justice system. The second is the deterrence. The deterrence is that the person who are given to crime, and the person should not be suffered again and again. Therefore, there should be a deterrence. The persons who are given to the life of crime should be sufficiently deterred, and for this purpose, we have a criminal justice system. So that a person is punished, and he is punished for a crime, is punished adequately, is punished so much that he is deterred from committing crime again. So that is the deterrence. Third is incapacitation. Incapacitation is also the same thing as deterrence, but in a little different way. In incapacitation, the person is kept away so that he cannot commit the crime again. Now, for that purpose, he is kept in prison for a longer period of time, say, well, imprisonment for life, and now we have also seen imprisonment for life till his natural death. These kind of punishments can be imposed for incapacitating the person from committing any crime, so that he does not commit any crime. Then one other aspect of the criminal justice system is rehabilitation. A person may commit crime out of passion, person may commit crime out of penury, or for any other reason, and for every crime he should not be punished for so much. The crime should compass that there should be a rehabilitation. If a person can rehabilitate himself, a person can improve. A person is not a die-hard criminal or a hardened criminal and can again assimilate into the society, then he must be given a chance to rehabilitate. And last is the restoration, which is that in a crime, when a property is stolen or a property has been taken by the criminal by use of violence or by use of the intimidation, etc., then that property which has been given from the victim, has been taken away from the victim, should be restored to the victim. Now, on these principles, the criminal justice system works. These are the basic principles of criminal justice system. However, as you see, on theory, the criminal justice system may appear to be a very simple thing, but in practical, it creates a lot of problems. It is not a very easy to deliver a criminal justice in a country, such a big and a large country like India, which is overburdened with population. Now, you must have known that the one basic reason which is given as far as the crumbling criminal justice system in India is that the overburdening of the court, the matters in the court. One reason is which ails this our criminal justice system is the lack of the sufficient number of judges, lack of infrastructure. Now, both these things go together. We have a lack of infrastructure and the negligence by the executive. There is a grave negligence towards the court, the judiciary, and the criminal dispensing system. And therefore, what happens is, or the justice dispensing system, what happens is, because of this negligence, which is the courts, there are insufficient number of courts, there is large number of litigations, large number of matters, the ratio of judges and the matters before the court, or the judges and the litigants, is totally skewed in this country. As far as we are one of the lowest. We have the lowest number of judges per person in the whole world. And therefore, because of this, the very few number of judges which we have, and the large number of matters which are pending in the court, it becomes a very chaotic. And it becomes chaotic to the extent that there is the tendency of which is a very growing, and which is a tendency which is required to be curbed, which is relating to unhealthy practices of settling the matters outside the court of law. We have seen in the past, in a very recent past, where where certain criminals were arrested for a rape and murder of a veterinary in Hyderabad. Some persons came to be arrested. They were accused of the crime of committing the rape and murder of that veterinarian. We do not know whether they were really the criminals, but they were extrajudicially terminated. Their extrajudicial killing of those persons was rejoiced by one and all, even by the lawyers, by the judges, by even the stakeholders of criminal justice system, apart from the executive, the corporates, the educated intelligentsia in this country. Everybody rejoiced. And the reason for this was because of this enormous amount of delay in the court proceedings in court of law. So what happened was that at that point of time, the Nirbhaya case, the accused in Nirbhaya case, had still not been hanged, or their punishment had not been inflicted upon them, which was the death sentence imposed on them. That was not carried out. And the people were getting impatient because of the number of delays in executing their punishment, resulting in that when a similar incident happened, and when the police took the law into themselves, they became the prosecutor, the judge, and the executor. All three in combined, and killed them extrajudicially. That on the ground of, or the reasoning, giving a false reason of that they were trying to escape, and therefore they had to be shot and killed. Now this kind of extrajudicial killing happened because of these amount of delays and indefinite delays which are caused in the court. And the reason for this indefinite delay, as I said, one of the most prominent thing is the delay because of the lethargy or the negligence shown by the executive towards the judiciary, the number of judges per litigant and per cases, and the total the number of the infrastructure provided for dispensing this justice. The second thing which did cause, apart from this, the number of judges, the other reasons which are often cited for the purposes of delay in court is the procedure. We have a very lengthy procedure, and I'm going to deal with that kind of, as I said, I will be dealing with the practical aspects of the criminal justice system and how certain things can be done to improve that criminal justice system so that the delivery of the justice can be expedited. Now, for that purpose, now we try to understand that we have a three-tier judiciary. At the lower level, we have the judicial magistrates, then we have a session court, then we have a high court, and ultimately an apex court. Now, the matters which comes from to the court has to travel all these three courts, and each court, as I said, each court suffers from the number of judges being less and the number of matters being more. And so what happens is, in that every stage there is a delay, and this contributes towards the frustration of the litigant. The frustration of the victim of the crime, the frustration of a person accused of a crime increases multifold because of this delay in these proceedings, which from court to court it goes. Now, the third aspect, which is the most important, is the inefficiency of the investigating authority. What happens in this coup? That the investigation is not carried out at the earliest. The law requires that the investigation should be completed at the earliest, and upon completion of investigation, a final report as contemplated under 173(2) should be laid before the court. Now what happens is now, friend, that the police take their own sweet time in completing the investigation, because they know that the law provides them 60 or 90 days to complete the investigation. For offenses which are not punishable with life and death, they have to complete investigation within 60 days, whereas the other offenses they can complete investigation in 90 days. So they take their own time in completing the investigation. Whereas if they could complete the investigation at the earliest and lay the charge sheet, the delay in filing or completing investigation can be avoided. Then we have a system of the committal to the Court of Sessions. And this is one thing which I would try to say, that this committal of this thing should be done away with. If we can do away with the committal proceedings, then what happens? That one step of delay will be removed. When the law requires that a certain offenses would be tried by the session court, then why the charge sheet can't be laid directly in that court, and why the whole process of the committal proceeding should go through? If we can avoid that part of it, then at least the proceedings, the criminal justice system can be expedited. My friends, you know that in all these special matters, many of the special matters, like under MOCA, like under the Prevention of Corruption Act and other provisions, the charge sheets are laid directly before the special court, and the special court is empowered to take cognizance of the case directly without committal. Since the law provides that the matter would be tried by a particular court, then I do not see any reason why the charge sheets can't also be filed directly in the Sessions Court in respect of offenses which are exclusively triable by the Court of Session. And the Court of Session can be empowered to take cognizance directly without holding a committal proceedings. Sometimes what happens is, and which is very practical, and many of you who are practicing in the court will realize, that many years elapse, many years, a long time goes, and the matters are not committed to the Court of Sessions for trial. The reason there are many reasons for this, but one of the reasons is the vacancy in the magistrate courts. And this vacancy in the magistrate court is because of insufficient number of judges. There are many, as I said, there are many reasons why the committals are not taken, but then it contributes toward delay. Then the third, which is most important, which contributes toward delay, is the bail proceedings. Unfortunately, in this country, the law of bail, though spelled out in various decisions of the Supreme Court, that bail is a normal rule and jail is an exception. But in practical, it is converse. Jail is a rule and bail is an exception. And for this reason, there are lengthy arguments on bail. Days and days are taken for arguing an application for bail, which should have been decided in minutes, and resulting in that the matters go on for a long time. The bail applications are taken from the magistrate court right up to the apex court, and each stage, because of the pendency of the bail applications, the matter in the trial court is prolonged, protracted, and it continues there there to remain there pending these bail proceedings. And in bail proceedings, the lawyers have a habit of arguing, as I said, for a long time, making lengthy argument, lengthy submissions on. So what can be done is to improve this, and the whole system of bail, of grant of bail, is required to be changed. Amendments are required to be made in the Criminal Procedure Code, so that what happens is that the bail proceedings do not take time, as it is in the Western countries. If you have seen in the Western countries, and if you read in the Western countries, the bail applications do not take much time. Very few the bail applications are decided within a minute or two. There are also they also file multiple applications for bail. Multiple motions for bails are moved there also, but they are decided by the judges in a very quick time, and no lengthy arguments are permitted in respect of bail applications. And this, I think, should also be an approach in the Indian criminal justice system also, that lengthy arguments for the purposes of bail, or to justify that their prima facie case does not exist, or that even if though prima facie case exists, the person is entitled for being released on bail, these arguments can be avoided, and to only see whether the person is a flight risk, whether there is a likelihood of the person committing the crime again, whether the person is likely to abscond, likely to tamper, considerations which are the normal the condition on which the law of bail is rests. These things can be avoided if the presence of the accused can be procured. There is no likelihood of the accused absconding or tampering with evidence. Well, the bail should be immediately granted. So liberalization of the law of bail will go a long way in expediting the criminal justice system. The third, as I said now, as far as it is the base. The fourth, which is very important, and as per which also contributes towards the delay, is the inefficiency of the judges. What has happened is that because of the negligence towards judiciary, the incentive to become judges is very less. And because of the incentives being less, the best talents in the country are not attracted towards the judiciary. An advocate practicing for about 7-10 years starts making a decent amount, particularly in the urban areas, in the metropolitan areas. And therefore, after 7-10 years of practice, when he is making a decent amount of money, he is not interested in joining the judiciary. And therefore, what happens is that the best talents are not attracted to the bench. And when best talents are not attracted to the bench, you get the mediocre, and the mediocrity sets in. And therefore, what happens is that the judges are a reflection of the bar. What happens is the bar, if the judges are mediocre, the bar is mediocre, and all these things that this sets in, and the delay, there is a further delay in disposing of the matters. Next is our legal education. Our legal education is at the moment made only with the purposes of giving a law degree. The person coming out of the law college is totally unequipped to practice in the field of law. He does not have any practical experiences. Though the bar, I'll tell you, the Bar Council of India and Maharashtra and Goa particularly have introduced various programs under their scheme of continuous legal education program. And under this continuous legal program, they hold lectures. Presently, the lectures are being held via internet, but through web. Earlier, the clubs were being held at various places, and various speakers were invited so that people advocates can join. Even persons who are not advocates, they would also join and participate in those programs and enrich themselves with the education so that they are better equipped to commence their practice and make a decent livelihood. This is again, as I said, the legal training, which is the lack of legal training which is imparted by the law colleges, also contributes towards the delay in. Now, having considered all these reasons for delay, let us consider what could be and how could the legal system can be improved and what improvements can be made in the criminal justice system. Now, in order to understand this, see what could be done at the we have to understand that the expediting of criminal justice is in the interest of both the society and as it is also in the interest of all the stakeholders of criminal justice system. So how do we expedite the criminal justice system? What do we do? And presently, and particularly in the present circumstances, where the country is facing this and the whole world is under the grip of this pandemic of COVID-19, where the courts have been shut, the courts are taking up only urgent matters, where the personal presence of the advocate and the parties are sought to be excused. How do we improve upon them? How do we deal with this kind of situation? Now, this is very, very a serious matter, which requires a grave on a serious thinking by all the stakeholders, all the persons, not only the executive, not only the judiciary, but the lawyers and the community as a whole. Not only the lawyers, the students of law, but also common citizens have and are stakeholders in respect of dispensing of criminal justice. Everybody has to participate, as I said, in a community has to participate in this, and we must all gather together our resources and to see to it that some changes are brought about whereby the criminal justice system will not suffer and we can have a further, if some mode we can develop a further mode or some further means whereby the system improves and the system improves in such a way that we all as a society improve and become a better society. Now, in this aspect, try to understand the particular thing that technology plays an important part. Why the technology plays an important part is to consider the fact is because that today's world is totally based upon technology. The whole world revolves around internet. And even the crime, the nature of crime has changed. We have seen the rise in cyber crimes. We have seen how the criminals have adapted to the changes in the technology. They have employed this technology more than what the lawyers and the judges and all other stakeholders of the justice system have done. They are even one step forward. They are always the criminals have been one step ahead of the executive and the judges. But even in accepting or using the technology, they are one step ahead. And therefore, the one aspect is the need of the technology and how we must use the technology to expedite the criminal justice system. Now, to understand this, one has to appreciate that our country is primarily and still is more than 60 to 70% is a rural area. We have a large number of courts, large number of lawyers, large number of these litigants living and persons living in the rural area. Since the population in the rural area is more, and we have very less number of people working in the cities, living in the cities, in rural areas, and even in semi-rural areas or semi-urban areas, the net connectivity is not great. The lawyers are not trained to operate a computer. They are not very familiar with laptops, and many of them cannot even afford that. So till such time, when the internet facility is improved in everywhere in the whole country, and the whole country has then access to the internet, till such time, to have or to carry out matters by video conferencing will not suffice or will not serve the purpose. What has happened is that though the courts now, the Supreme Court and all the high courts have started functioning via video conferencing. However, this facility of video conferencing is being used and utilized only by the lawyers practicing in the big cities and towns where they have proper net connectivity, where they have computers, laptops, and the new generation who are more accustomed to use of these facilities like computer and laptop, etc. Now, therefore, it is there. What happens is that a person in a rural area or an older person who is not used to this technology is left out. You must have already read that Bar Council of India, in an affidavit to the Supreme Court, in a representation they made by way of representation, they submitted that 90% of the lawyers in India are not trained in this technology, and they have still to adopt. But as I said, we will have to make changes. This COVID situation is likely to remain here and remain in the world for some more time. So we have to make changes in our lifestyle. We have to make changes in the field of law, in the field of practice, and how do we go about in the court proceedings. Changes are required to be made. And we will have to live with these changes. And for this, we must train ourselves in this technology. We'll have to see that we can appear on video conference, conduct matters on video conference, and so forth, that we are not left out. Because what will happen is that if we are unable to operate through video conference, and if you are unable to, you will lose work. If you are unable to appear before the court and file matter, you will lose work. The clients will go to a lawyer who can file or make an application through video conferencing. So technology will come. There is to make this thing. The courts are doing up with the paper filing. They would be insisting upon e-filing. For e-filing, everything which is required from scanning to filing, everything is required to be learned by the advocates. So there has to be a training first to given to all the advocates, all the participants, as I said, of these, all those who are stakeholders in this justice or delivery system. They must be trained in this. Many judges, even they are not, they are also technology challenged. They also are not so friendly with computers, and they are not also friendly with these kind of changes in law. They also are required to change themselves. They are also required to train themselves, so that what we can do is that we can do some expedition can be brought about in filing of the matters, hearing of the matters, and for the expeditious decisions in this matter. Now, apart from this thing, as I said, technology, though there will be as a practice, there will be many difficulties in employing this technology, particularly in the field that technology can be employed as far as arguments are concerned. Technology can be employed as far as the filing of the proceedings are concerned. This thing, but however, when it comes to the the real thing, which is the trial, where the facts are to be collected, there that this practical difficulty would come arise. The reason is, how do you employ this technology for recording evidence? Though evidence can be recorded by video conferencing, but however, without the presence, the physical presence of the witness being procured, a witness deposing from a far place, a lawyer questioning the witness from another place, and the accused being lodged in another third place, it will become a nightmare. It will cause an enormous difficulty, apart from the fact that the witness can be coached, witness can be tutored, witness may be given unprovided answers, by or answers be hinted to him. Somebody can just answer this and place it before the witness and from behind the screen, and he can read those answers. So those things have to be avoided, can't be avoided. That the technology cannot help in this type of matters. Then the lawyer, how does the lawyer perform? The lawyer performs on the base without taking instruction, even if he has taken the instructions by visiting the jail, or by on phone, or by any other means, or even if the video conference is allowed to the lawyer and the client, those may be limited for the purposes of preparation for cross-examination. But when ultimately the cross-examination is going on, at that time, if the lawyer needs an instruction, or if the client wants to give an instruction, such instructions cannot be given, and that a grave prejudice would be caused to the accused and to his defense if the witness is not personally present. And therefore, the law prescribes the physical presence of the witness in the court, the physical presence of the witness and the accused and the lawyer. The advantage of physical presence can never be undermined. This cannot technology. But then, as I said, in the present circumstances, where you have to maintain social distancing, where the procurement of an accused from the jail, or for the procurement of the witnesses because of lack of the restrictions in travel, they may not be possible. Then till such time, what happens is that you have to proceed in the manner of through video conferencing. There would be some certain difficulties, certain disadvantages, but to those advantages, they have to be addressed. How to overcome those disadvantages, something will have to be done. Unless this is done, those disadvantages will continue. But if it is seen that the disadvantages are more, the prejudice is more, then this the trial by video conferencing will also have to be abandoned. But at the moment, what has happened, which is, as I said, the courts being overburdened with work, the prisons are overcrowded, though the courts have now, in consideration of the situation, have decided to ease the prison population. Certain directions are given to release the accused persons who are facing a sentence of or facing offenses for punishable to 7 years, or who have been convicted for offenses which are not punishable for more than 7 years, or those who are not facing offenses of serious nature, to release those kind of certain directions are made, and that will definitely ease the prison population. But these are temporary measures, because the release is temporary. It's only a parole for a particular number of days. They are required to surrender at the end of the parole, or as soon as the situation improves. So therefore, what would happen, that the prison population has become uncontrollable. This has become uncontrollable because of the large number of pending matters. And if this pandemic which continues, the trial courts will not work, the trials will not progress. All other matters pending in the suits, petitions, all pending matters are not taken up. So the amount of matters will continue to increase. There will be a large number of pendency. How do you get about the pendency? Therefore, it is necessary and imperative that the courts, the lawyers, all other executive, and as I said, all other stakeholders in this judicial dispensing system should come together and start functioning by use of technology. There's no point in holding or having only video conferences for urgent matters. Let us proceed with regular matters by use of technology, and let the technology, this thing, as I said, there would be difficulty faced. There would be large number of difficulties because, as I said, there would be technical difficulties. There would be difficulties where the lawyers, because of they are not trained, or the parties are not trained, and there would be difficulties in this, as I said, in holding proceedings, where because of lack of instructions, etc., there would be certain difficulties will be there. But we have to overcome. We have to see these difficulties, how the difficulties are minimized. But the whole initiative should be that the court should start function to the maximum capacity and to start matters at the earliest. And all other and lengthy arguments, as I said, long arguments, they should be done away with. If necessary, if the court feels in a particular matter, in a particular circumstances, that lengthy arguments are required, then the parties may be asked to submit written arguments. The court can consider written argument and pass orders. Lengthy orders also should be avoided, because the time taken for lengthy orders also consumes the time for dispensing justice, and therefore that should also be avoided, and the matters should proceed. You cannot keep accused persons, you cannot keep persons behind the bars indefinitely. Persons who are charged of serious offenses, you can't just say, all right, you are charged with serious offenses, so you'll be kept under lock and key in the prison, but your matters will not proceed because of the pandemic. Despite pandemic, despite this, the right to have an expeditious trial, that is not suspended. His fundamental right of a person to have an expeditious trial, that is still remains. That is not suspended because of the pandemic. He is entitled to. There's a breach. How to breach this? How to make this thing, that Article 21 of the Constitution of India, which provides for life and liberty. How this comes in place in an important aspect in this matter. How to balance that right of a lawyer, the right of an accused, with the present circumstances where the courts are totally crippled due to this pandemic. So we cannot allow the the criminal justice system to be crippled by this pandemic. We'll have to fight this pandemic and come out with certain means and modes of bypassing this pandemic so that the justice delivery system continues to perform without interruption, smoothly, and plays and also acts very swiftly and expeditiously. Now, to act expeditiously, as I said, all the intermediary proceedings that should be avoided. And there, everybody has to part. Even the lawyers, they have a greater role as the judges are. They should not see to procure, to proceed, or to see that matters are prolonged, protracted. Unnecessary arguments, objections, challenges by way of revision or by filing writ petition should be avoided. Lengthy arguments on framing of charges. We have seen this consumes in certain matters, particularly matters like the scam in the financial scams. Lengthy arguments are advanced for days together by different accused persons as far as framing of charges are concerned. Such lengthy arguments on the charges should be avoided. And if necessary, as I said, the written argument should be accepted and the court should swiftly start framing of charge. All other challenges, these frivolous challenges by way of revision, writ petition, etc., should be avoided. And this is the responsibility of the lawyers. But the lawyers themselves should take upon themselves that in this condition, they'll play a proactive role and would contribute towards expeditious disposal of the matter and would not in any manner protract or prolong the proceedings. If that is done, then it will go a long way in dispensing the criminal justice system as expeditiously in the present circumstances. Thirdly, which I said, we must also make available, as I said, the technology to each and every party. Internet facility is not available to everyone. Internet facility is very poor in certain part of the country. And to that extent, it is for the executive and the court to emphasize upon that such technology is supplied to nook and corner of the country, and that no lawyer, no litigant is left out and he can participate in the proceedings. The court has also to take a proactive role in this. After, they must see to it that the investigations are completed at the earliest. Police does not prolong or protect the investigation, completes the investigation swiftly and files charge sheet. The court proceeds with the matters as early as possible, and the prosecutor and the court that only minimum number of witnesses required to prove the case be examined. No multiplicity of witnesses, no examination of witnesses which are not of any use, and examination of unnecessary witnesses should be examined. Lengthy and long and cross-examinations should be avoided. The parties should be asked to be concise and in the cross-examination as well as summation, that is the final argument. And if at all they require to make lengthy arguments, the argument should be submitted in. These by this way, we can expedite the proceedings. As I said, all intermediate proceedings, particularly like the bail proceedings, the revision proceedings, or the writ petition proceeding, they have to be minimized. Their time taken for these proceedings should be minimized. And if these are minimized, and particularly in this situation, they should be at the minimum. The court should not permit such proceedings, unnecessary proceedings, and direct the parties to proceed with the matter at the earliest. In this way, we can all contribute towards the improvement in the criminal justice system. As I said, each and every stakeholder has to contribute. The state has to see that there are no unnecessary prosecutions. We have seen a large number of cases are filed. Unnecessary prosecutions are being filed. One thing which ails the country is too many laws. In this country, we have too many laws, and each and every infringement of law should not be taken to court. We have seen how the laws are being misused. Particularly, today we are facing that the cases. The persons who are practicing in criminal court will know that how the POCSO, how this act is being misused, how persons are being falsely implicated, how persons' lives are being ruined by prosecution under these kind of offenses. Same is the case for our other offenses also. So therefore, it is at the first instance, it has to be seen. And as the executive will have to improve. They will have to improve the infrastructure of the courts, the infrastructure of the negligence which has been shown over the years toward the judiciary and the infrastructure of judiciary, that is required to be changed. The executive must improve the infrastructure. Infrastructure should in the form of the technology available to the court, the sitting arrangement, the space in the court. Because with all this, because of the social distancing, we require a larger space in the courtroom. We have, as I said, we are overpopulated, both by way of lawyers, by way of the litigants and everything. So therefore, we require larger space. We require a better technology. And therefore, it is for the executive to see that better technology. Nothing can be done if the technology does not improve, if we do not have a better infrastructure. Now, once you have a better infrastructure, then it is left first to the police to see that there are not unnecessary prosecutions. Unnecessary prosecution, police, they themselves can make out. They should not be wary of the media, and then and arrest and charge sheet any and every person. They are the persons who investigate. They know what is truth behind the story, and if they find that the prosecution does not merit the going to the court, they should have the liberty. They should take the onus on themselves and not to prosecute. That will greatly reduce the number of matters in the court. Then the court, as I said, has to take a proactive role. The court should see that all other intermediate proceedings are not lengthy. They are not protecting the main matter. And they should curb all the intermediate proceedings at the earliest. Decide the bail matters quickly. Decide all the intermediary challenges at the earliest and quickly and expeditiously. Then it comes to the role of the lawyers. The lawyers themselves have to see that they do not protect the proceedings in any manner. They also are supposed to play a very proactive role. They must see to it that the matters go on as expeditiously as possible. The bail applications should be, and arguments on bail application should be restricted. The bail matters should be decided, as I said, by the court at the earliest. And once the bail matters are decided, and the matter comes to the stage of trial, the court, the lawyers should contribute towards expeditious disposal of the matter, and by use of technology. At the moment, it is only the technology will have to be used. Though, as I said, there are certain changes will have to be made into the law. The physical presence of the accused and the physical presence of the witnesses may not be possible. And the examinations will have to be carried out through video conferencing. But there, certain, as I said, the court can take and adopt certain methods by way to see that no prejudice is caused, that the evidence is recorded in a fair and proper manner. And for these purposes, as at the witnesses may be asked to give evidence from a particular from the nearest court or from a nearest center can to be established, where there would be an authority to see that the witness is not coached, where the authority would have to will be there to supervise and see that the evidence is being recorded in a proper and a fair manner. As far as the instructions of the advocate from the client is concerned, the court will have to see that maximum liberty is given, the maximum possibility help is given to an advocate to see to secure the instructions from the client. So the advocate cannot work without the instruction of the client, and therefore he must be given all means, all help to obtain proper instructions from the client. And if during the recording of evidence, if the advocate feels or if the client insists that I want to give certain instruction, then the court must be, as I said, play a proactive role and should stop the further recording of evidence to enable the advocate to take instruction, to enable the accused to give instruction to his lawyer so that the prejudice is not caused. Each person who is responsible in this justice system has to play a very proactive role, has to consider that the technology, they should adapt to the technology and adapt to all these challenges so that we can deliver. We can have a very expeditiously disposal. The courts have to see that presently maximum number of judges are unemployed. They are unemployed in the sense they do not have work. Only 1 or 2 judges are working. Rest of the judges are sitting at home. So therefore, their services should also be utilized. All the judges should be employed. All the judges should be hear the matter on conference. We can restrict the number of hours. We can restrict the number of the matters to be heard. But if the matters are heard, if even a few matters are heard, and those are decided expeditiously, as I said, without any in these lengthy arguments, without any intermittent proceedings or protective proceedings, then those matters will be disposed of, those matters will be decided, and on the next day, fresh matters can be heard, fresh matters can be decided, and that will greatly relieve and the number of unburden the number of pending matters. So what is required is that the court should work full and the proceedings should go on as quickly as possible. It is for the court. There's nothing now stops for the court to work full strength. What prevents the lawyers, if it is to be through video conferencing, then all other proceedings can happen. Whatever possible may, they should be done. And avoiding social contact, social distancing. If the courts can function in the trial courts or in the magistrate court, that if the courts can function by maintaining social distancing, the matters should be listed, and only those matters should be taken up on that particular day. There's no reason for keeping 100 matters on board and then taking up 1 or 2 matters only. Only few matters should be taken up on board. So there are less number of litigants in the court, less number of advocates in the court, and therefore, and those matters which are listed will all be taken up for hearing. So as I said, we'll have to balance. There are many ways where we have to play a part and participate. But at the moment, it is that what is necessary for each and everyone is to use the technology. Everybody should become trained in technology and to see that the technology is used to the best and advantage of the litigant, for the advantage of the lawyers and all persons participating in the judicial justice system. If anybody is not this thing, the lawyers fraternity should see to it, and there are the bar council and the bar associations. They can also play important part in this and see to it that the advocates who cannot themselves afford a computer or a laptop are provided laptop or computer facilities in the court, or who have not been trained, they are trained in these facilities. So to that extent, the bar council and the bar association can participate. This is, as I said, a subject which has been spoken, read, written by so many persons. Everybody has a different take on this. But this was my take as far as the practical aspects of criminal justice system is concerned. I think I have taken more time. So at the moment, I'll take questions if anybody has any question.
Thank you so much, sir. I'll be informing with a few questions. We'll take it up.
Yeah, please go ahead.
One of the questions by the participants is, what is the advantage of the physical presence of the accused or witnesses, basically in the examination of witnesses, and why can an online video presence not suffice?
As I said, the online presence of the witness will not suffice into one, because the witness can be tutored, witness can be coached. If there may be a person who is not visible on the screen, but maybe supplying the answer to the witness. So therefore, to avoid that, this thing, as I said, that will be online recording of evidence should be at some independent place, which is supervised by some authority, either by the court or by some court appointed officer. And therefore, only in such circumstances, the video conference can be evidence on video conference can be taken. The disadvantage of having a recording of evidence on of a witness on the video is that the cross-examiner, one who cannot understand the quality of his voice. See, many things are learned by knowing the pitch or the volume of the voice in which the witness is answering. Secondly, the expression of the witness is not clear. So what the cross-examiner normally learns is from the demeanor of the witness, understands the nature of his evidence from the voice. That advantage is lost to the cross-examiner. And as far as the accused is concerned, his fundamental right of being present in the court, evidence being recorded in his presence, in his physical presence. Now, though this can be provided for, as I said, under video conferencing, the court says that, all right, the physical presence does not mean only a physical presence in the court. A physical presence can be also procured through video conference. But the disadvantage is, as I said, of giving instruction to a lawyer. Now, if an accused is present before the court, he can always get up and with the permission of the court, provide instruction to the lawyer. During the cross-examination, whenever when some answer is given or one certain question arises. But this goes against the accused person if he is not physically present. He is in jail. Therefore, in such circumstances, it will be for the accused to request the court that he wants to instruct his lawyer and that the evidence of recording of the evidence of the witness is postponed. And there, as I said, the court has to play a proactive role, and depending upon the nature of the question, whether it is the request made by the accused or the under trial is genuine, whether he really needs to give instruction to the lawyer or whether the lawyer really needs the instruction, that has to be educated by the court, and then on that basis, the court can decide the request of the under trial and agenda.
We will take another question, sir.
Yeah, please go ahead.
How during the lockdown period the requirement of proof of service of notice be accomplished, and whether there is any amendment required, and will it be sufficient to show the notice is sent to the last known email address without proof of delivery? So what are the alternatives for the same?
I think, see, the law has already made many changes as far as the notice is concerned. Notices through mail, email, are now accepted by courts. So I don't think that the notices being sent via mail should not be accepted by the court, particularly in this lockdown condition. And the courts would readily accept it even if you have given a notice via mail. Yes, it would be open for the other side to come before the court and say that they were not served, or that the mail which the wrong mail, and therefore they have not received the mail. But then it is the burden on that the notice has not been served. Well, in these circumstances, is the onus shifts on the other side, and once the party shows that yes, I have sent a mail on the last known email address or the mail address given by the party, and the party would be presumed to have received the notice.
Thank you, sir. There's one question from one of the participants. She wants to know, could you please describe what a committal proceeding entails?
What is?
What is the committal proceeding entails? Committal proceeding.
Committal, you see, there is a committal under the Criminal Procedure Code. There's a procedure of inquiry before the magistrate. When a charge sheet is laid before the court, as a final report under 173(2) is laid before the court, the magistrate is supposed to inquire into the charge sheet, find out whether the offences are triable by him or triable exclusively by the Court of Session. If the offences are triable by the Court of Session, then he's supposed to commit the case or to send the court or transmit the case to the Court of Session. These are called committal proceedings. Now, in committal proceedings, it is many a times the arguments are heard. The applications are moved by the advocate, stating that though the police have charged me with an offence which is triable by session court, the charge sheet or the facts and circumstances of the case does not merit that the case should be transferred to Court of Sessions. So these lengthy arguments are advanced, which are advanced that yes, that sometimes they are advanced that there is no prima facie case, sometimes they are advanced that there is no offence made out for committing the case to the Court of Session, and that the offence made out is only triable by the magistrate. Now these type of proceedings consume a very long time, and as I said, many a time this delay is furthered because of the vacancy in the magistrate's court. Now, if the matter is if the magistrate is vacant, no other magistrate is going to take up committal proceedings, because this is not considered to be an urgent matter. The matter will languish in that court for months and years together till some new magistrate comes up and then proceeds to commit the case. By the time, many a times, what happens, the accused if the accused is on bail, he gets frustrated. He is not attend. He becomes irregular in attending the court. Warrants are issued against him. Proclamation is issued against him, and this further contributes toward delay in committal proceedings. Because in the present setup, as far as session trials are concerned, the session court, which is competent to try the cases of the session triable offences, is not competent to take the cognizance of that offence directly. The court no session court can take cognizance of an offence directly. So therefore, the matter is required to be committed to it by the trial magistrate, which, as I said, requires a grave amendment to be made at the earliest, and this committal proceeding should be done away with. This is archaic. This does not serve any purpose. This should be avoided, and directly the matter should go before the sessions court.
Thank you, sir. We will take up the last question for the session. Has criminal profiling and behavioral analysis of a criminal contributed in derivation of the conviction or acquittal of the same? If yes, to what extent?
Please repeat.
Has criminal profiling and behavioral analysis of a criminal contributed in the derivation of the conviction or acquittal of the same? And if yes, to what extent?
As far as criminal profiling is concerned and the criminal behavior is concerned, these are are the procedures which are adopted in the field of investigation. They help in the investigation for the investigator to understand the person who has committed the crime or who could be the culprit who have committed the crime. This does not in any manner contribute towards the deciding a matter against an accused, because under the law which is prevalent and which is still prevalent in our country, every person is presumed to be innocent. So every person is presumed. So criminal profiling. So say in a case, then what if a person is a criminal profile? You can't, even if a person is known to be an habitual or a hardened criminal, or a person given to a particular time of crime, his case is not judged on the basis of his profile. It is not judged on the basis of a criminal history. Only when there is a conviction, if there is a previous conviction, that will come, that evidence regarding previous conviction can be given at the time of sentencing. Otherwise, even previous conviction has no bearing as far as a criminal trial is concerned. Therefore, criminals, the profiling or behavior has got no role as far as the education of any criminal matter is concerned. They, on the ascent, they may cause some kind of prejudice. As I said, this kind of prejudice is always, which is played by the media, by the role of the media in a trial where there are sensational cases and the matters are decided by the media. The media decide that the person is guilty or not guilty, or the person is, but most of the time the person is guilty, and they overplay how the investigation has taken place, how the evidence has been collected, what is the evidence, and repeatedly telecasting or repeatedly writing about this matter play on the mind of the public, and the public themselves, they decide, yes, the man is guilty of a particular offense, though he may be completely innocent. Now this happens, so the courts, the lawyers, who are also public, are firstly public. They are also sometimes get influenced by this media and publications of this, and this sometimes may come play some part in the education of the women, but that is, as I said, is a very dormant time. It does not play any important role, and therefore criminal profiling or behavior of a criminal has no role as far as the criminal justice system at the present is concerned. It is only relates to the investigation stage.
Thank you so much, sir, for such an informative lecture about the challenges of the courts and law, and the challenges the courts and the lawyers will face while utilizing the technology in future in the criminal justice system. Thank you for accepting our.
Thank you, Gauri. Thank you, everybody.